My name is Rowan Ellington, and before everything spiraled out of control, I lived a quiet life practicing criminal defense in a mid-sized Colorado town. I'd been doing it for 14 years, specializing in cases where innocent people faced false accusations. Most days I worked from home, reviewing case files in my small office overlooking the street. My neighbors knew I worked from home, but they assumed I did something mundane, maybe consulting or freelance work. I never corrected them. I'd learned early that people treated you differently when they knew you were a criminal defense attorney. They became guarded, performative, careful. So I kept my expertise private. Even my closest friends didn't fully understand how sharp I was, how many false accusations I'd dismantled with nothing but evidence and strategy. I preferred it that way. Being underestimated meant people revealed their true selves around me, showed me exactly who they were before realizing I was watching, documenting, preparing. But one man mistook my silence for ignorance, my privacy for weakness, my quiet life for vulnerability. That mistake cost him everything. Brennan Lockridge lived 3 houses down in a colonial that screamed old money and new arrogance. He was 42, worked in commercial real estate, and believed his wealth entitled him to control the entire neighborhood. From the moment he'd moved in 2 years ago, he'd been insufferable, complaining about everyone's lawns, parking, property modifications. He especially hated me, though I'd never given him reason. Maybe because I didn't attend his pretentious parties or fawn over his expensive cars. He'd made snide comments about my work-from-home situation, implying I was unemployed or doing something frivolous. He'd told neighbors that women who don't have real jobs were dragging down property values. I'd ignored him for 2 years, focusing on my work defending people from exactly the kind of arrogant bullying Brennan represented. I documented his comments casually, not expecting to need them but trained by years of legal work to preserve everything. Then one Tuesday evening in late September, Brennan decided to escalate. He stormed onto my porch, his face red with manufactured rage, and made me his target. Brennan's fist pounded on my door while I was reviewing case files. I opened it to find him jabbing his finger toward the street, toward his restored 1967 Mustang. "You damaged my car," he snarled. "I have proof you scratched it backing out this morning. That's criminal vandalism, and I'm pressing charges." I looked at him calmly, noting the performance in his anger, too rehearsed, too precise. "I haven't moved my car in 3 days, I said quietly. "Then you did it earlier this week," he snapped, adjusting seamlessly. "Either way, you're paying for repairs. $5,000. Or I'm calling the police and my lawyer." He leaned forward, voice dripping with condescension. "You wouldn't understand how the law works, but trust me, you're liable." Then he smiled, clearly enjoying what he thought was my helplessness. I'd already noticed something crucial, though. His timeline was impossible. He'd claimed I backed out this morning, but now he was saying earlier this week. The inconsistency was small but fatal. More importantly, my car had been in my garage for 5 days straight due to a work deadline. I had timestamps to prove it. Brennan didn't wait for my response. He turned and walked to the middle of the street where several neighbors had gathered, drawn by his shouting. "Just so everyone knows," he announced loudly, "Rowan Ellington damaged my vehicle and refuses to take responsibility. Some people have no respect for other people's property." Mrs. Chen from next door looked uncomfortable. The Johnsons exchanged glances. Brennan continued, his voice carrying. "It's what happens when people don't have real jobs or real responsibilities. They get careless. They think rules don't apply." He gestured toward me dismissively. "Just another clueless suburban woman who thinks she can get away with anything." The words were designed to humiliate, to establish his narrative before I could defend myself. Several neighbors pulled out phones, not to call anyone, but to record. Mrs. Chen was filming openly, her expression troubled. I watched Brennan perform for his audience, noting every detail, every inconsistency in his timeline. I was already building a case in my mind, cataloging evidence, identifying weaknesses in his story. Then I turned and went inside without saying a word. Let him think silence meant defeat. For 3 days, I stayed silent. Brennan interpreted this as weakness, as confirmation he'd intimidated me into submission. He made sure to be outside whenever I left my house, making pointed comments about people who damage property and hide. He told more neighbors about the incident, embellishing each time. Now I'd deliberately scratched his car out of jealousy, and I'd been hostile and threatening when confronted. I let him talk. I let him build his story higher and higher, each lie adding weight to what would eventually collapse on him. While Brennan performed for the neighborhood, I did what I did best, documenting everything. I recorded his statements from my doorbell camera. I noted the timeline. Damage allegedly occurred sometime in the past week when I backed out. I photographed my car's position in my garage, unmoved for 5 days. I reviewed my security footage showing my car never moving during his time frame. I pulled my garage door sensor data showing it stayed closed. And I started building a case, quietly and methodically, the way I'd done professionally for 14 years. Brennan had no idea what was coming. On Friday, Brennan made it official. He filed a police report, and Officer Martinez called asking me to come to the station. I drove there calmly, already knowing what I'd find. Officer Martinez showed me Brennan's report. He'd claimed the damage occurred Tuesday morning when I recklessly backed out and struck his parked car. He'd estimated damages at $6,000 and included photos of scratches on his Mustang's passenger side. He'd also described me as hostile and unstable, suggesting I might be dangerous. But reading his statement, I recognized a fatal legal error. Brennan had specified exact times, exact locations, exact circumstances, all of which could be definitively disproven. He'd been so confident in his lie that he'd over-detailed it, giving me multiple attack points. He'd stated I backed out at approximately 8:15 a.m. on Tuesday, September 19th, and that he'd witnessed it from his driveway. Every specific detail was another nail in his coffin. Officer Martinez, I said calmly, I'd like to provide evidence demonstrating Mr. Lockridge's statement is false. He raised an eyebrow, interested. I hadn't mentioned my profession yet. That would come later, at exactly the right moment. I called Harlan Price, an investigator I'd worked with on dozens of cases. Harlan specialized in evidence collection and had an almost supernatural ability to find footage others missed. I need help with something personal. I explained the accusation and police report. Harlan listened, then laughed sharply. He doesn't know what you do, does he? No, I confirmed. He thinks I'm unemployed. This is going to be good, Harlan said. Give me 2 days. I hung up and looked at Brennan's house through my window. He was outside washing his Mustang, clearly confident his false report would force me to pay. He had no idea he'd just activated the same criminal defense machinery I used to protect innocent clients. The same analytical frameworks, evidence-gathering protocols, strategic thinking, all now focused on dismantling his lie. Brennan had picked the worst possible target. For 14 years, I'd specialized in exactly this: false accusations, malicious prosecution, evidence analysis. I knew every statute, every precedent, every defensive strategy. And Brennan had never bothered to ask what I did for a living. His arrogance would be his downfall. Harlan worked fast. By Sunday evening, he called with findings that exceeded expectations. I pulled footage from the traffic camera at your intersection, he explained. Partial view of your driveway and the street where Lockridge's car was parked. I waited. Your car never moved during his time frame. Not Tuesday morning, not any morning that week. Camera shows your garage door stayed closed Monday evening through Friday afternoon. That confirmed what I knew. But Harlan continued, more interesting, Lockridge wasn't even home when the alleged damage supposedly occurred. Camera caught him leaving Monday night around 7 p.m., not returning until Wednesday morning. So he couldn't have witnessed anything Tuesday morning because he wasn't there. I felt the case breaking open, pieces aligning perfectly. There's something else, Harlan added, voice carrying that tone, meaning he'd found something devastating. You need to see this footage personally. We met the next morning at a coffee shop. Harlan showed me security footage from a neighbor's camera with a better angle on Brennan's car. The footage showed Brennan on Tuesday afternoon, hours after claiming the damage occurred, standing beside his Mustang. Then he practiced. He rehearsed his rage, gesturing angrily at his car, pointing toward my house, trying different expressions of outrage. Textbook malicious prosecution. I went to the police station and asked for Officer Martinez. I brought my laptop and a USB drive with all of Harlan's evidence. I'd like to submit evidence disproving Mr. Lockridge's report, I said calmly. Officer Martinez looked skeptical at first. Civilians making counterclaims was common, and most lacked meaningful proof. But I was thorough. I showed him the traffic camera footage proving my car never moved. I showed timestamps proving Brennan wasn't home when he claimed to witness the damage. Then I showed him the security footage of Brennan rehearsing his accusation. Officer Martinez's eyebrows shot up. He watched the rehearsal footage twice, his expression hardening. "This is deliberate," he said slowly. "Not a mistake or misunderstanding. He planned this accusation." "Yes," I confirmed. "Filing a false police report at minimum, possibly criminal fraud, definitely grounds for malicious prosecution." Officer Martinez looked at me differently now, reassessing. "Are you an attorney?" "Criminal defense," I said. 14 years. I specialize in false accusations." His expression shifted to something like sympathy for Brennan. "We'll be forwarding this to the DA's office," he said. I left the station knowing the wheels of justice were turning. 2 days later, Brennan learned his police report was under review. He didn't take it well. I was pulling weeds in my front yard when he stormed over, face purple with unrehearsed rage. "You tampered with evidence," he shouted. "You manipulated footage to make me look bad. That's illegal, and I'm suing you for defamation." I stood slowly, brushing dirt off my hands. Several neighbors emerged, drawn by his theatrics. Mrs. Chen was filming again. "I submitted security camera footage from public and private sources," I said evenly. "All timestamps verified, all sources documented. Nothing was tampered with." "You're lying." Brennan snarled. "You're trying to frame me because you damaged my car and don't want to pay." I let him rant for 30 seconds, let him dig himself deeper with more false accusations. Then I asked the question I'd been saving. "Brennan, do you know what perjury is?" He froze. His mouth was open, another accusation forming, but my questions stopped him cold. The word hung in the air between us, heavy with legal implications he was just beginning to understand. Around us, neighbors watched silently, finally understanding what they were witnessing. This wasn't a neighborhood dispute, this was criminal. I didn't wait for Brennan to answer. I recited the Colorado perjury statute from memory, voice calm and professional. Under Colorado Revised Statute 18-8-503, a person commits perjury if, in any official proceeding, they make a materially false statement which they do not believe to be true. Filing a false police report falls under official proceedings. The penalty is a Class 4 felony, punishable by 2 to 6 years in prison and fines up to $500,000. Brennan's face went pale. Around us, neighbors watched silently, understanding shifting. "You told Officer Martinez you witnessed me damage your car Tuesday morning," I continued. "But security footage proves you weren't home Tuesday morning. You also rehearsed your accusation on camera, demonstrating premeditation and intent to file a false report." I didn't," Brennan stammered, trying to backtrack. But it was too late. Every word documented. Every lie recorded. Every threat witnessed. "I suggest you retain legal counsel," I said quietly. "The DA's office is reviewing your report, and they take false accusations very seriously." I turned and walked inside, leaving Brennan in my yard, finally understanding his mistake's magnitude. 3 days later, Dorian Kessler called, Brennan's attorney. Kessler had a reputation as a competent civil lawyer handling real estate disputes. He sounded tired, like he already knew this case was a disaster. "Ms. Ellington," he said carefully, "I'm representing Brennan Lockridge. I was hoping we could reach a friendly resolution without further court involvement." "I'm not interested in friendly resolutions," I replied. "Your client filed a false police report intending to damage my reputation and extort money. That's not a misunderstanding, it's a crime." "I understand your frustration," Kessler used the placating voice lawyers used with difficult parties. "But perhaps we could—" "Your client lied under oath," I interrupted. "He made materially false statements in an official proceeding. He rehearsed his accusations on camera, demonstrating premeditation. And his continued making defamatory statements even after being informed his report is under investigation. Silence. Then, you're an attorney. Criminal defense. 14 years. I've handled dozens of false accusation cases. More silence. I'll advise my client accordingly, Kessler said, and hung up. I knew what that meant. He'd tell Brennan this was unwinnable, that he'd made a catastrophic error. But I doubted Brennan would listen. I was right. Instead of backing down, Brennan brought in his family. The Lockridges were known locally for their real estate holdings and inflated self-importance. Brennan's parents, Richard and Caroline Lockridge, showed up Saturday morning in expensive casual wear and practiced superiority. We need to discuss this nonsense with Brennan, Richard said without preamble. You're making a mountain out of a molehill. Our son made a simple mistake, and you're trying to ruin his life. Your son filed a false police report, I said calmly. That's a felony. Oh please, Caroline waved dismissively. Nobody's prosecuting over a neighborhood dispute. You're just vindictive. We're prepared to offer $20,000 to drop this and sign a non-disclosure agreement, Richard added. More than generous for some scratches that may or may not have happened. They thought they could buy their way out, throw money at the problem. I'm not interested in your money, I said. I'm interested in ensuring your son faces consequences for attempting to criminally frame me. Caroline's face hardened. You're making a stupid mistake. We have resources you can't imagine. We can make your life difficult. They just made a strategic error and didn't realize it. After the Lockridges left, I did what any good attorney does. I pulled public records. Colorado property records are publicly accessible. What I found was fascinating. The colonial where Brennan lived wasn't in his name. It was registered to his late grandfather's estate, tied up in probate proceedings dragging on for 3 years. The property was technically estate-owned, not by Brennan or his parents, with multiple competing claims from other family members. A legal mess that could take years to resolve. Even more interesting, liens against the property for unpaid property taxes dating back 2 years. The Lockridges were living in a house they didn't legally own, in property with significant debt attached, projecting wealth they didn't actually have. And they'd threatened me with their resources. I saved everything to a secure folder. I wasn't planning aggressive use, that would be petty. But it was leverage, tucked away if the Lockridges continued their intimidation. And it confirmed what I'd suspected. Brennan's arrogance was built on pretense and legal complications. The discovery would prove useful sooner than I expected. The following Monday, I filed my counterclaim. I'd spent the weekend preparing a malicious prosecution motion with attached evidence, security footage, traffic camera timestamps, the rehearsal video, documented statements from Brennan continuing to defame me after his report was under investigation. The filing cited Colorado statutes on false reporting, harassment, and abuse of process. I included character witnesses, neighbors who would testify Brennan had made defamatory statements to establish a false narrative. I attached documentation of my car's immobility during his alleged time frame. I included expert analysis of the scratches on his car, which didn't match my vehicle's bumper height or angle. Everything was thorough, professional, devastating. Within days, the district attorney's office opened a formal review of Brennan's report. They assigned prosecutor Lisa Chen to evaluate whether criminal charges were warranted. Lisa called me, sounding impressed and slightly amused. Ms. Ellington, this might be the most thoroughly documented false report case I've ever seen, she said. You basically did our job for us. I'm motivated, I replied. He tried to destroy my reputation. Well, he's definitely facing consequences, Lisa confirmed. We're scheduling a hearing. Brennan tried delaying through Dorian Kessler. The judge denied every motion. The hearing was scheduled for 3 weeks later. During that time, the neighborhood shifted. The same neighbors who'd watched Brennan's initial accusation with uncertainty started treating me differently. They'd seen police involvement, heard about the DA's review, begun understanding this wasn't a petty dispute, it was a serious legal matter. Mrs. Chen apologized one afternoon, saying she'd been too quick to believe Brennan. The Johnsons invited me to a barbecue for the first time. Even strangers started nodding politely. Brennan noticed the shift. He'd gone from neighborhood authority to pariah in less than a month. I saw him less frequently, and when I did, he looked diminished, stress showing in his posture, confident swagger replaced with hunched shoulders. 2 weeks before the hearing, Doreen Kessler called again. Mr. Lockridge would like to make an offer, he said. He's willing to admit this was all a misunderstanding, withdraw his police report, and apologize publicly if you'll drop your counterclaim and potential criminal complaints. An offer born of desperation. Brennan finally understood what he faced. What's the apology? I asked. Kessler read a prepared statement that was passive, vague, took no real responsibility. It was pathetic. The apology Kessler read was worthless. I acknowledge there may have been confusion about the incident. In retrospect, I may have overreacted. I apologize if Ms. Ellington felt unfairly accused. If I felt unfairly accused. May have overreacted. May have been confusion. Every sentence minimized, avoided admitting what he'd actually done. This isn't an apology, I said. This is a non-apology that admits nothing. It's what my client is willing to offer, Kessler replied. Then your client can make his offer to the judge, I said. I'm not pretending this was a misunderstanding. He deliberately filed a false police report with intent to extort money. He rehearsed his accusation. He continued defaming me after his report was under investigation. Those aren't misunderstandings, they are crimes. Ms. Ellington, be reasonable, Kessler tried. Going forward will be expensive and time-consuming for everyone. My client is offering an easy resolution. I don't want an easy resolution, I said. I want accountability. I paused, then delivered 8 words that would end negotiation. We'll let the court decide your client's credibility. Kessler sighed heavily. I'll inform Mr. Lockridge. The hearing was 2 weeks away. Brennan had run out of delays, excuses, ways to avoid facing what he'd done. The courtroom was smaller than ones I usually worked in. This was a preliminary hearing to determine whether criminal charges were warranted. Brennan sat with Doreen Kessler at one table, looking pale and nervous. I sat alone at another, evidence organized in neat folders. Judge Patricia Hartwell reviewed Brennan's original police report first, reading aloud key accusations. I'd damaged his vehicle through reckless driving. The damage was deliberate. I'd been hostile when confronted. Then she asked Brennan to confirm his statement. Is this an accurate representation of what you witnessed? Judge Hartwell asked. Brennan hesitated, glancing at Kessler, who nodded slightly. Yes, Your Honor, Brennan said, voice uncertain. That was his second mistake, reaffirming a lie under oath. I stayed calm and silent, waiting. When Judge Hartwell asked if I had a response, I presented evidence methodically. First, traffic camera footage showing my car never moved during his alleged time frame. The courtroom murmured. Then footage proving Brennan wasn't home when he claimed to witness the damage. Murmurs grew louder. Finally, security camera footage showing Brennan rehearsing his accusation. The courtroom went silent. Judge Hartwell leaned forward. Mr. Lockridge, do you wish to amend your statement? Brennan panicked. Instead of admitting his lie, showing remorse, taking responsibility, he doubled down. That footage is taken out of context, he said quickly. I was just upset about my car. I wasn't rehearsing anything. Judge Hartwell's expression didn't change. The footage shows you practicing gestures and expressions before making your accusation. How is that out of context? I was just thinking through what happened, Brennan stammered. Then, incredibly, he tried a new lie. Maybe I was mistaken about the exact day. Maybe it wasn't Tuesday. But the damage is real, and someone caused it. Doreen Kessler closed his eyes briefly. Brennan was digging deeper with every word. My attorney friend Marcus Webb, observing as I'd requested, stood and approached the bench with permission. He dropped additional evidence on the table, documents I'd prepared as insurance. Your Honor, we have timestamps from Ms. Ellington's garage door sensor showing it remained closed for 5 consecutive days. We have testimony from 3 neighbors confirming they saw Mr. Lockridge's vehicle undamaged Monday evening. We have expert analysis proving the scratches don't match Ms. Ellington's car's dimensions. and we have surveillance from 3 different angles corroborating the same timeline. Dorian Kessler buried his face in his hands. Judge Hartwell spent 10 minutes reviewing evidence in silence. Then she looked up, expression leaving no doubt about her conclusion. "Mr. Lockridge, your original police report was knowingly false," she said, voice carrying judicial authority. "The evidence demonstrates clear premeditation and intent to file a false accusation. Your attempt to modify your statement just now constitutes additional false testimony under oath." Brennan started to speak, but Judge Hartwell raised her hand. "I'm referring this matter to the District Attorney's Office for perjury review. Additionally, I'm imposing a fine of $5,000 for abuse of the court system, and I'm issuing a restraining order prohibiting you from approaching, contacting, or making any statements about Ms. Ellington." She turned to me. "Ms. Ellington, you have grounds for a substantial civil suit. I encourage you to pursue it." The gavel cracked sharply. Brennan sat frozen, finally understanding consequences. But I wasn't finished. Criminal penalties were satisfying, but they didn't address harassment, attempted extortion, defamation. For that, I needed to file civilly. As we left, I saw Brennan's parents in the hallway. Their expressions had shifted from superiority to fear. They finally understood their son hadn't picked a fight with a clueless suburban woman. He'd fought a criminal defense attorney who specialized in exactly this. 2 days after the hearing, I filed a comprehensive civil lawsuit against Brennan Lockridge. The suit included 5 claims: reputational damage for false accusations made publicly, emotional distress for harassment and stress, harassment for continued intimidation after being informed his report was false, abuse of process for weaponizing the legal system, and malicious prosecution for the entire orchestrated campaign. I attached documentation of every defamatory statement to neighbors, every threat issued, every moment of intimidation. I included witness testimony. I calculated damages conservatively at $75,000, though actual harm to my reputation and peace of mind was incalculable. Brennan's homeowner's insurance refused to cover him. They sent a denial letter citing willful misconduct exclusion. Insurance doesn't cover intentional harmful acts, and Brennan's premeditation was extensively documented. He would pay any settlement or judgment from his own pocket. Within a week, the Lockridge family contacted me through Dorian Kessler, begging for a settlement meeting. I agreed, curious what they'd offer now that Brennan faced both criminal and civil consequences. The meeting would reveal just how desperate they'd become. The settlement meeting took place in Dorian Kessler's office. Richard and Caroline Lockridge sat beside Brennan, all 3 looking diminished and desperate. Kessler sat at the head, settlement proposals spread before him. "Ms. Ellington," Richard began, earlier arrogance gone, "we'd like to discuss resolving this. Brennan made a terrible mistake, and we're willing to compensate you appropriately if you'll drop the civil suit and not pursue criminal charges." I waited, saying nothing. Caroline jumped in, "We're prepared to offer $50,000. That's more than your suit asks. You'd be fully compensated, and everyone can move on." They thought this was about money. They still didn't understand. "I don't negotiate with bullies," I said calmly. The words landed like stones. "Your son didn't make a mistake. He planned a campaign of harassment and false accusation designed to extort money and damage my reputation. He rehearsed his lies. He continued defaming me after being caught. That's not a mistake, it's calculated malice." "We understand you're angry," Richard tried. "I'm not angry," I interrupted. "I'm ensuring accountability. Your son needs to learn actions have consequences, that you can't weaponize the legal system without facing serious repercussions." Brennan had been silent, staring at the table. Finally, he looked up. "What do you want?" he asked, voice small. Before I could answer, Kessler's phone rang. He glanced at it, frowned, excused himself to the hallway. Through glass walls, I watched his expression shift from confusion to concern. He returned 2 minutes later looking uncomfortable. "There's been a development," he said slowly. "A real estate investor has contacted the probate court handling the Lockridge estate. They've made an offer to purchase the outstanding interest in the property where Brennan currently resides." Richard's face went pale. "What? Who?" But I already knew. I'd been contacted 3 days earlier by Marcus Webb's real estate investor friend looking for properties with complicated title situations. I'd mentioned the Lockridge house as a case study. The investor had been intrigued by probate complications and tax liens, researched the property, determined the estate was motivated to sell given mounting debts, and made an offer to purchase the controlling interest legally through the estate. The investor's name is Sarah Chen, Kessler said, glancing at his phone. Then he looked at me, making the connection. Any relation to Lisa Chen, the prosecutor? Sisters, I confirmed. I hadn't orchestrated this. Sarah had acted independently after Marcus mentioned the opportunity. But the timing was perfect, almost poetic. The property Brennan was so proud of was being sold out from under him. The letter arrived at Brennan's house 1 week later. I know because I was at my window when he collected his mail, and I watched his face drain of color as he read. The letter informed him Sarah Chen had successfully purchased the controlling interest in his grandfather's estate, including the house where he resided. Per probate agreement terms, Brennan had 60 days to either purchase the property at fair market value, including all back taxes and fees, or vacate. The purchase price was listed, $450,000, which Brennan clearly didn't have given his insurance had refused to cover his legal expenses. The letter concluded with information about his new landlord and where to send rent checks if he chose to stay as a tenant rather than purchase. The new landlord was S. Chen Properties LLC, Sarah Chen's investment company. But the property manager listed, the person Brennan would deal with for any issues or negotiations, was me. Rowan Ellington. The same woman he'd mocked for not understanding how law works was now his landlord. The woman he'd tried to destroy now controlled the roof over his head. He would pay me rent, follow my rules, or leave. I watched Brennan read the letter 3 times, saw him slump against his mailbox, saw the exact moment he understood the full scope of his defeat. Brennan chose to move out rather than pay rent to me. I heard through neighborhood gossip his parents arranged for him to stay in a rental property they owned across town, though the Lockridge's financial situation was becoming strained under legal fees and settlements. The restraining order remained, so Brennan couldn't approach me to negotiate. He had to communicate through Dorian Kessler, who clearly wanted nothing more to do with this disaster. The DA's office ultimately chose not to pursue perjury charges. The false report and judge's findings were enough, and prosecutorial resources were limited. But Brennan now had documented history of filing false reports and lying under oath, which would follow him professionally and personally. The civil suit settled 2 months later for $60,000, paid in installments from Brennan's personal accounts. I donated half to the Colorado Innocence Project, an organization helping people wrongfully convicted by false accusations. The rest covered my legal expenses. On moving day, I was in my front yard when the moving truck arrived. Brennan emerged briefly to direct movers, saw me, and quickly looked away. He moved out quietly, refusing to meet my eyes, utterly defeated. The arrogant neighbor who'd believed he could intimidate anyone was broken by the very laws he'd claimed I didn't understand. Silence isn't ignorance. And respect isn't optional.